Good morning. This is your Kelso Report for Wednesday, March 8th. I'm your host, Clark Kelso. We got 4 cases today dealing with law of evidence, criminal sentencing, an important arbitration decision, and criminal procedure. We begin with the Ninth Circuit decision involving evidence law, in particular the hearsay rule. The Ninth Circuit waded into the hearsay rule in one of its many exceptions in Wagner versus County of Maricopa, which is essentially a wrongful death action that's dressed up as a Section 1983 claim for purposes of federal jurisdiction. The decedent, who was seriously mentally disturbed, had been taken into custody by the police after he was seen wandering around a neighborhood and, when approached, started yelling, "Kill me, kill me," and then struggled with police officers. At the jail, he was quickly identified as needing a psychiatric referral. But before transporting him, the police wanted to change his clothes to jail clothes. Well, he refused, and was then forcibly undressed and dressed in jail clothes. After a week in jail, he was bailed out by his family. Well, 2 or 3 weeks later, he was in his mother's car when she had a minor accident. When he was told the police were coming, fearing that he would be rearrested, he ran 4 or 5 miles from the car. The next day, he died from acute cardiac arrhythmia. The plaintiff's theory of the case was that the traumatic experience of the jail ultimately led to his death. In order to prove that the decedent believed he had been traumatized at the jail, the plaintiff wanted to introduce testimony from his sister about what the decedent had told her. The district court ruled this testimony was inadmissible hearsay, and then also ruled inadmissible any expert testimony connecting the decedent's death with the decedent's state of mind as testified to by the sister. The jury found in favor of the county, which is not very surprising given the exclusion of the testimony. The Ninth Circuit majority, over a dissent, held that the sister's testimony was not hearsay, since it was not being offered to prove the truth of the underlying events. Instead, it was being offered supposedly only to prove the decedent's state of mind, which would be a relevant consideration given the plaintiff's theory of what caused the death. According to the majority, the sister's testimony should have been admitted, as well as the expert testimony based upon the sister's testimony. So the court remanded for a new trial. Next, we have a sentencing case involving plea bargains. When the United States Attorney's Office breaches a plea agreement, the usual result is a reversal of the sentence and a remand for sentencing before a new judge. That is what we see in United States v. Whitney, where the assistant U.S. attorney breached a deal with the defendant by disclosing to the sentencing judge certain incriminating admissions the defendant made to the government in the course of cooperating with the government on their investigation. And the USDA, also the assistant district attorney, improperly urged imposition of a sentence above the low end of the guidelines, contrary to the deal. As a result of the disclosure and the government's argument for a sentence above the low end of the guidelines, the sentencing judge appears to have imposed a much longer sentence on the defendant than would otherwise have been the case. The Ninth Circuit vacated the sentence and remanded for resentencing before a different district judge. The lesson here is simple. A deal is a deal. Next, we have a very important arbitration decision from the Ninth Circuit. Now, those of you who have been following our reports know that there is a running disagreement between California state courts and the federal courts, usually the U.S. Supreme Court, regarding the preemptive reach of the Federal Arbitration Act. California state courts have been working for a little over a decade now to limit the preemptive reach of the FAA so that they could strike down arbitration clauses in a variety of consumer and employment contracts. In two cases decided a decade ago, the California Supreme Court established a rule forbidding arbitration of claims seeking broad public injunctive relief. The first case, of Broughton versus Cigna Health Plans of California, involved a request for injunctive relief under the Consumers Legal Remedies Act against allegedly deceptive advertising. The second case, Cruz versus Pacific Care Health Systems, extended that holding to injunctive relief under the unfair competition law. Well, in yesterday's decision, Kilgore versus KeyBank National Association, the Ninth Circuit held that the Broughton-Cruz rule was preempted by the FAA as recently interpreted by the United States Supreme Court in AT&T Mobility versus Concepcion. Concepcion re-emphasized that the saving clause in the FAA permits agreements to arbitrate to be invalidated only by generally applicable contract defenses, but not by defenses that apply only to arbitration, or that derive their meaning from the fact that an agreement to arbitrate is at issue. Well, the Broughton-Cruz rule does exactly what the Supreme Court forbids. It creates a special rule applicable only to certain arbitration clauses and expresses a state hostility to arbitration that is inconsistent with the federal policy set forth in the Federal Arbitration Act. I think it's going to be very interesting now to see how California's state courts react to this decision, because the Ninth Circuit decision is really a pretty powerful shot across the bow of the state courts. We may soon see the end of the battle over arbitration with the federal courts prevailing. But don't count the state courts out just yet, because they've been very creative in avoiding the FAA's preemptive reach. And who knows, they may still have a trick or two up their sleeves. Finally, we have a criminal procedure case out of state court involving the double jeopardy clause. Pretty straightforward case. The defendant had been convicted on multiple counts in a prior criminal proceeding, including a conviction for making a criminal threat against someone named Marquez. The people conceded in the prior proceedings that insufficient evidence supported his conviction for that offense. The convictions in the first proceeding, the other convictions in the first proceeding, were reversed on other grounds. And the people then tried to prosecute the defendant again for the alleged threats against Marquez. The Fourth District held that the double jeopardy clause clearly barred this prosecution do-over, noting that the double jeopardy clause forbids a second trial for the purpose of affording the prosecution another opportunity to supply evidence which it failed to muster in the first proceeding. The defendant in this case was convicted on several other counts, but the court reversed the conviction as to threats against Marquez, and that resulted in vacating a 16-month consecutive sentence which had been imposed with respect to that charge. A good day for appellate counsel. And that's it for today's Kelso Report. Have a great day in the law.